Hello and welcome back. My name is Georgianne Ford with the Alpha Center for Divorce Mediation. And we are back today with one of our attorney mediators, Mike Routh. Welcome back, Mike.
Hey, Georgianne.
And Mike's here to talk to us about the designation of beneficiaries and how important, where does that play when it comes to divorce? Is that right, Mike?
Right. That's our topic today. And basically, Georgianne came up because I just had an experience with a client that unfortunately didn't turn out too well for them. So, one of the steps that we take in our mediation program is that we make sure that we go through all the things that the clients need to do when they're going through this divorce. And one of the things that we focus on is this issue of beneficiaries that are named on their various assets, like their bank accounts, their mutual fund accounts, their retirement accounts, life insurance policies. And we really try to hone in on the fact that you need to make sure that the beneficiary is who you want it to be. A lot of times when you're married, you list your spouse as the beneficiary. So it might be listed as the person's name followed by the word spouse. Well, here in Pennsylvania, there's a law that says once the divorce is issued, there's an automatic revocation of any beneficiary that's listed as a spouse. They're basically viewed as having predeceased the holder of the policy, the account, the retirement account, etc. So they're unable to get those benefits if they're still listed in that manner. So we really try to remind our clients that you need to go through all those assets and put the person in that you want to be able to receive that asset in case something happens to you. We always say that if you want to leave your spouse in there as the person named in that manner, that's fine, but you still need to change the language to just reflect their name only.
Mike, why would they leave the name? Because they do want to leave the life insurance under to give to the ex-spouse, or is it because they're expecting the ex-spouse to do something with that money?
Right. Well, that's a good question, Georgianne, because fortunately here in mediation, a lot of our clients are still on good terms. So sometimes out of the generous of their heart, they do leave each other on those policies, just because they've been together for a long time and they want to make sure that they're taken care of. But more times than not, it's because they have children together. So they want to leave that other party on there to be responsible for the funds that get dispersed for their children. So it's really for the benefit of the children. They leave the spouse on there as a trustee and then the children as equal beneficiaries in the policy. So just to relay the experience that happened with one of my clients is that I got a phone call from one of the parties and their spouse had passed away in a life insurance policy that they had agreed to make that change to because of the importance of the money being used for the benefit of their daughters. It didn't get changed, right? And so the person who held the policy passed away. They left the designation of the word spouse on next to the name of the person, and now there's a problem with getting the money. And what happens is even if the insurance company does pay out the policy to that beneficiary, the ex-spouse, they're still required to reimburse anybody that would challenge that at the probate level. So even if they get the money in error, it's not necessarily theirs. They have to be careful. They have to watch out for, if a different family member challenging the estate later on. But let's just say the insurance company notices that, and then the money will go to the estate. Well, now that insurance money that was supposed to be tax-free is now going to face those estate taxes and those expenses that go along with that process. So that full amount that they've been paying into for all those years is now going to get reduced. So there are some pitfalls in there.
So would it be best to make it more black and white, like to definitely change it to our children's names?
Right. So you can designate the children, and that's what a lot of people will include in their agreement. is that the children are going to be named as the beneficiaries and the spouse is going to be named as the trustee. The thing that, about that is that you can put that in your agreement, in your settlement agreement, which is important because that can be used to support the payment of the policy to the correct people, right? The fact is, in my situation, they didn't list that arrangement in their settlement agreement, so they were stuck either way. So it is, as I was saying from the beginning, it is truly important to make sure that you go through and adjust these things. And we always add, at the end, if you're still not quite sure, then take that extra step and get a will drafted, because your property is not going to pass as expected anymore. Once you get that divorce decree, you're no longer married, and your property will no longer go directly to your spouse. So if you wanted to go, if you have intent for it to go to certain parties, then you need to make those arrangements by drawing it out in a will. And we do, take our clients through a checklist at the end to make sure that we've addressed all those things. The thing about it, at the end of the day, Georgiana, is that ultimately neither myself can make those changes nor the court can make those changes. So it is the responsibility of the clients to do that. So, we do run into these situations where, if one party doesn't do it, then unfortunately, they have to face the consequences of that.
So do you recommend it? Is there amount of time that you recommend for them to make those changes, or is it like immediate when you're going through divorce?
I would always err on the side of doing it sooner than later. Obviously you have until that divorce decree is issued, but some people are so relieved to get the divorce decree in the mail and be done with it that that they forget about those responsibilities as well.
Yeah.
And it is difficult to continue to stay on clients and remind them to do these things. Like I suggested, we talk about it all the way through our mediation program, and then especially at the end, when we take them through the checklist, and then once again when the decree is issued, we remind them to go back and take a look at the checklist to make sure that they address all those issues. So we do our best to hammer it home.
I think the checklist is great. I'm such a proponent of checklist because that's where you'd say we didn't do that, especially when you revisit it with us. So that's what makes the fact that you guys go through all that really valuable with the mediation firm Alpha Center. Is there anything else you want to add? It was quite a story.
No, like I said, it's unfortunate that these things have to happen, and that they come up this way, to remind us that we have to make sure that we do take care of our responsibilities. Ultimately, in this case, it's going to end up hurting the children in this relationship more than anybody else.
Well, let's hope they get a good amount of that money they deserve.
Right.
Thanks for coming on, and we look forward to having you back next month.
Thanks, Jan.
Sure. Any of you have any questions for Mike or anybody at the Alpha Center for Divorce Mediation, specifically on this topic even, feel free to call 1-800-310-9085.